Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, Mr. Camden, when you're ready.
Good morning, Your Honors, and may it please the Court. It was error for the District Court to deny the motion to suppress in this case. There are
Is
two
it
issues.
possible for you to speak up or move the microphone closer?
Absolutely, Your Honor. I
Thank you.
apologize. There are really two issues in the background on this case. First is whether Officer Walker's conduct in seizing and arresting Mr. Coe constituted an unreasonable use of force in violation of the Fourth Amendment, and if so, second, whether suppression would be the appropriate remedy for that violation. This is a little unusual for a criminal case. The typical criminal Fourth Amendment suppression issue...
You also made a Bruin challenge. Are you you're abandoning that? I just want to make sure.
Your Honor, I believe that is currently foreclosed. This court has held
Right.
that even as applied challenges under the Second Amendment are not available.
Thank you. I just wanted to confirm that.
Yes, we'll rest on the briefing. I understand there are some cert petitions pending, but I don't intend to pursue that here.
Okay, thanks.
Thank you, Your Honor. But going back to the Fourth Amendment issue, this is a little different than the usual criminal case, which involves a lack
So
of...
we're here on an excessive force claim, is that correct?
Essentially, yes, Your Honor.
And that's, I guess, leads to my first question. If we're here on an excessive force claim, why isn't an excessive force claim the proper subject of a 1983 suit rather than a subject for the application of the exclusionary rule?
It could be both, Your Honor. So Fourth Amendment issues arise in both contexts. Number one, just because a 1983 action is available does not mean suppression is automatically excluded as a remedy. In addition, there's, of course, the procedural bars. Heck versus Humphreys, I believe, requires that the criminal charges be resolved in Mr. Coe's favor before pursuing a claim.
They could be both, but it also could be separate, because the whole question of a search would go to the whether there was a legitimate basis for the search, and then the question of the seizure would go to how the search was executed. And those might be two separate things.
I agree that it would be I think it would be the same general issue, whether the officer violated the Fourth Amendment in the seizure or search of Mr. Coe,
But
his arrest.
the question of remedy is an important one here. We're here on a conditional plea, and the question, if there was a problem with the search, that would be involve the application of the exclusionary rule, which the Supreme Court has been careful about expanding. And if there's a question of seizure, you have a totally different remedy, which would be one for damages. And given the difference in the remedial scheme between the search and the seizure in excessive force cases, and given the Supreme Court's reluctance to expand the application of the exclusionary rule when there was a proper basis, if there is, for the search or the stop, it might seem for remedial purposes and analytical purposes, that it's good to disentangle those two.
To address, I think, one of the points in the middle there, I think it's important not to get ahead of the Supreme Court. I'll recognize and agree that the trend, I think, has been towards limiting the scope of the suppression remedy in a criminal case. But it has not been abolished yet, and it has not been shunted all to these 1983 actions.
But if there was a proper basis for the search, then why would we exclude the evidence
There was a proper
that was
basis.
obtained by virtue of the search? So your objection must, do you object to the question, to the matter of whether there was a proper basis for the search?
Yes, Your Honor. There was a proper basis for a search, a hypothetical search that the officer never conducted. The search that and the seizure that he conducted that led to the search involved an unreasonable application of force.
So, Mr. Camden, can I ask you, what specifically and precisely as you can do you believe the officer did that was an unreasonable seizure within the meaning of the Fourth Amendment? As in the excessive, putting aside the search question, right?
Yes.
So I want to be as granular as we can. What action did the officer take that you allege constituted excessive force?
Pointing his firearm with no safety, with his finger on the trigger, into Mr. Coe's side and back as he held him against the car with his left elbow.
Okay, so it's not the initial drawing of the firearm, because
No.
as I understand, that happened before Mr. Coe was out of the firearm.
Right.
So it's the pointing at him after he's out of the car?
After he's out of the car, yes. Well, so
But didn't he, almost as soon as the officer approached the vehicle, didn't appellant start throwing, try to run away and start throwing the drugs?
no, Your Honor. So the officer was walking towards the front of the building, and
Right,
he stopped, he saw, he shined his flashlight in.
right.
And then he switches, and you can watch this on the body cam. He switches the flashlight to his left hand, opens the car door, and draws his
And
firearm.
when he opens
as
the
he's
car
opening the
door, that's when they start, what does appellant do when the officer opened the car door?
He freezes, Your Honor.
And then what?
And then he leans about 10 degrees forward as
To
he's opening
grab
it.
the,
Right.
the drugs and start throwing them around? And he
Oh,
also
that's-
tries to run away, doesn't he?
Well, that's not until later in the encounter.
Okay.
What happens is the officer, and this is in the joint appendix, the officer actually testified at 95 that he opened the door and attempted to grab Mr. Coe. So he opened the door. Mr. Coe sits there. He's leaning with his hands in his lap, leaning about 10 degrees forward. He doesn't shift left or right. He doesn't reach for anything. He doesn't make any furtive movements. The officer reaches in and grabs him. And as he grabs him and is pulling him out of the car, he places his left elbow on Mr. Coe's. He doesn't allow him to fully exit. The officer is standing right there at the door. He jams him in between the car door.
And this is cutting it awfully fine, isn't it? Because, as I understand it, there was the circumstances here would give rise to the reasonable apprehension of danger, would they not? You've got an area in which drug trafficking is prominent. You've got an officer who is alone in the evening. You've got a situation where there's a finding that the officer saw an individual with drugs and handling bags of some white substance. And then we have this argument about, well, what exactly came first? Did he spot the gun before the tasing, or did he do this or that, and what's the sequence here? But when you take the situation as a whole, which was that alone, late at night, somebody's handling white substance, a gun is found in the waistband. The man would have easy access to the gun, the officer would be in reasonable apprehension, not just of danger, but of, an apprehension of his life. And didn't the situation in its totality lead to a legitimate concern on the part of the officer that his life was in danger?
At the point that he pulled his gun out and pointed it in Mr. Coe's back, no, Your Honor. So this court's cases have approved taking out a firearm, and the government's brief lists some of these cases. There was Burgess, where the officer pointed it downward. The court's authorized drawing the weapon, Foote versus Dunnigan, for these late-night encounters where there are drugs involved. But it has never...
And you're making the distinction here that, that he not only drew it, but because he had his finger on the trigger?
Yes, Your Honor. So
And probably because he also testified, quote, "You never know when you're going to have to shoot someone."
That's
So
one of
he's
the insights,
arguably
I
just
think.
itching to shoot somebody, from
Well,
your perspective.
And I submit, I'm not going to discuss it too much now because we don't have any details, but we
But
did.
yeah, he has been involved since then in a shooting.
I just have one factual question and then a question about your argument. The factual question, as I understand it, so your position now that I understand it is that it's pointing the gun at him after he's out of the car. But he drew the gun before he was out of the car, correct?
Correct.
And so the claim is that the officer should have holstered the firearm? Because if you're not challenging the initial drawing of the firearm, then your argument has to be it's by not putting the firearm away or by continuing to point it at him. That's the argument?
No, by pointing at it. So
Okay, pointing. So having it out
his
is...
finger on the trigger.
Right.
And having, okay, and then the second question is, are you challenging the district court's factual finding that your client tried to flee once he was out of the car?
No.
Okay.
No, it's clear that that's what was going on at that point.
Sure.
And that gets into, I think, the but-for causation here we have really, which is this is not a case where there was some prior, and this is on the suppression remedy, this is not a case where there is some prior act that the officers failed to do, so an omission, like in Hudson with the knock and announce requirement, where they just didn't do that, but everything else they did was exactly as authorized by the warrant. This is a situation where the officer, from the very beginning of the encounter, and under Barnes versus Felix, I think cautions against trying to...
What do you say he should have done? Kept his firearm holstered throughout the entire scenario?
No, he can remove the firearm from the holster. There is a difference, and there's throughout the cases, between removing the gun and having it ready in case it needs to be used, and finger on the trigger, elbow at the neck, pointing it into somebody's side, when that person has their hands up like this and is frozen in place. And that distinction runs throughout a lot of these cases. We've cited a lot of, it mostly arises in 1983 cases where people are suing, obviously, when they have...
Where do you think that distinction best arises in these cases? I mean, what language would you point us to?
Well, in the cases the government cites, their brief at 17, they highlighted in Burgess that the officers draw their firearms but pointed them downwards. And in Foote versus Dunnigan, this court noted that the authorization is essentially to draw the weapon. And in all the cases from Tennessee versus Garner, the Supreme Court's first sort of case...
So Foote versus Dunnigan, you're saying that the case says the authorization is to draw the weapon, but then does the case go further and say, but not to point it at anyone?
I don't believe that was at issue in that case or argued as a point.
So your case is unique.
I think we are in a gap in the case law. I'll agree to that, absolutely.
So, it seems to me we're in danger of slicing this very fine, and one of the things we have to ask ourselves is, how do you teach what goes on in the courtroom at the police academy? Because we really want the officers of the law to respect the decisions of the courts. And this seems to me a hard kind of case to translate into a discernible rule in a police academy course. And I don't know what the rule you would have us draw is. to the extent that I can draw a rule from this is, does an officer legitimately feel, given the totality of the circumstances, that his life may be in danger? And that's the only rule that I can draw. I can't draw, well, you can only unholster your gun in this particular circumstance or that particular circumstance. You can put your finger on the trigger here, but not there, and everything. And that's a very difficult rule to teach to police officers in the police academy. And it seems to me that the basic rule, and the one that is teachable, is, do you legitimately feel that your life may be at risk? And you have to credit the district court's overall impression to some extent. Whether we quibble with this finding or that finding, the bottom line was that he declined to suppress the evidence. And his ultimate conclusion, because he listened to the individuals involved, I assume, and his ultimate conclusion was, these circumstances taken as a whole do not warrant suppression. And you might want to say in rebuttal, when you have a rebuttal, why was that an erroneous bottom line to extract from all these circumstances?
I see my time is up.
Well, you have rebuttal time, and maybe my colleagues, if they have further questions of you, I'm willing to, you can judge that.
I just have one on the firearm. So this court has said a number of times that the nexus between drugs and violence creates some level of reasonable apprehension on the part of the officer. I'm thinking of U.S. versus Saki and maybe one or two other cases. And how would you have us distinguish those cases which seem to say that an officer who confronts someone that they think is in possession of at least some drugs can draw a firearm without violating the Fourth Amendment?
I think they can draw a firearm. We're not challenging sex.
So this is where the pointing and finger on the trigger is? Okay.
Exactly, Your Honor.
Okay.
Yep. This is 2 steps beyond just having the gun ready.
Understood. Thank you.
Mr. Arnold, I'd be happy to hear from you.
Good morning, Your Honors, and may it please the Court. Daniel Honold for the United States. I think I'll start with the excessive force analysis, unless the Court wants to start elsewhere. Just 2 clarifying points to begin my remarks here. First, in Foote versus Dunnigan, which Your Honors discussed with my friend here just a moment ago, some of the language from Foote says that during the stop, Foote placed both of his hands on the steering wheel, at which point Dunnigan, the officer, exited his vehicle, drew his gun, pointed it at Foote, and identified himself as a county deputy sheriff. He did not have time to display his badge.
Does the excessive force claim implicate an exclusionary rule remedy, or is it properly reserved for a damages action, given the Supreme Court's skepticism of expanding the exclusionary rule because of the high social costs it's paid? Are these different questions because of the different remedial schemes that are available?
There are different remedial schemes available, and as the Seventh Circuit held
Can you
in...
put that microphone close?
Yes, Your Honor. There are different remedial schemes, as Your Honor has recognized. The Supreme Court has been very hesitant to expand the exclusionary rule to other circumstances, and this is not a circumstance in which this Court should recognize the expansion here.
What do I do about the fact that this court has suppressed evidence based on an excessive force violation? Edwards.
So Edwards is not that case, Your Honor. Edwards was...
The court did suppress, well, there was constitutionally unreasonable force, right? In Edwards, that's what the court said. It was a constitutionally unreasonable law enforcement. It wasn't a search case, right?
It was a search case, Your Honor.
Oh, it was a search case?
Yes.
Why?
Because it was analyzed under Bell versus Wolfish, and the court there explicitly said that it was analyzing it under an unreasonable search doctrine. So that was the thrust of that case. That was the case in which the officers conducted a constitutionally impermissible strip search on the public street that led to
But
the...
why are strip searches I mean, I understand that we have this distinction doctrinally between search and seizure cases, but I mean, there was no question that in Edwards they were allowed to search Mr. Edwards. The question was whether they were allowed to search Edwards in the particularly invasive, humiliating, graphic way they searched Mr. Edwards. I mean, I know you're going to try really hard to move that into the search bucket, but it seems like what the objection was not they didn't have probable cause, not that they didn't have reasonable suspicion, not that they didn't have a good enough reason to search him. It's that they searched him in a way that was unconstitutional. And that, it seems really hard to just wall that off and say that's categorically different.
I understand, Your Honor, but it is categorically different for a couple of different reasons. That Bell versus Wolfish and that sexually invasive line of search cases is like a discrete body of doctrine that the court was operating under, and there's no evidence that it's intended to...
I can understand why the panel in Edwards ruled, why the majority in Edwards ruled the way it did. The circumstances there were so hideous, I'm not going to repeat them. But at least, you know, whether it's a subject of a legal distinction or not, I don't know. But I would say that the circumstances here are dramatically different from those in Edwards. And for one thing, there's no sexual component.
Yes, Your Honor.
And that makes a big difference.
I think that's what separates the sexually invasive search doctrine from excessive force claims in general, and of course here we're dealing with the latter. I would also just point, Your Honor, to the Collins case from the Seventh Circuit. That's another case, it's citing Watson. It's talking about whether excessive force is available as a remedy, and it actually discusses Edwards and says...
This is the really, really, I'll say, breezy Judge Posner opinion, or are we talking a different opinion? Or
I
he just
think-
sort of declares something and just doesn't really give any reasons other than just declaring it?
With respect, I think that's the Watson opinion, Your
Okay.
Honor, and I don't think it's quite that breezy. He does go...
It's pretty breezy.
He does go kind of stepwise through the factors of why suppression wouldn't be available as a remedy, including the mismatch between the interests at stake and sort of the purpose of suppression as a remedy. But Collins is actually a different, a per curiam opinion that Watson predated Edwards, Collins postdates Edwards, and so it had an opportunity to discuss it, and it found that it wasn't a meaningfully on-point case for basically the reasons that I'm alluding to, Your Honor.
One of the things about this case is that, you know, we have a number of events about, you know, what took place when, you know, what was the precise timing of the tase, what was the, when was the weapon drawn, what was actually seen. And so there are a number of minute questions here and findings here dealing with chronology and the sequence of things as they unfolded. But I'm wondering, in this kind of case, isn't there some respect that should be paid at the end of the day to the ultimate conclusion drawn by the court that heard the evidence? And the ultimate conclusion here was that this did not warrant suppression, that the circumstances surrounding the interaction between these two individuals were sufficiently fraught and sufficiently suggestive of not just danger, but of the loss of the officer's life.
Yes, Your Honor.
I mean, what is it? This overall impression due certain respect because he heard the evidence and we have not. And this kind of encounter, this sort of encounter, the actual trier of fact or the person who conducts the exclusionary rule, here, is it a comparative advantage to us? We're at a comparative disadvantage And that's particularly true, I think, when there's a question, what happened when, who did what when. Is that a fair assessment?
That's a fair assessment, Your Honor. The deference and the respect that this court affords to the district court who heard the evidence is in deferring to the factual findings that the court makes. And I think that
I
leads
agree
to...
with that, but part of what made the circumstances here fraught, and that someone, whether the officer or others might be shot, was that this particular officer testified that whenever there's any type of crime that's committed, regardless of the type of crime, it could be a misdemeanor, he's going to pull his weapon. That's what he testified to. And he also testified that that was because you never know when you're going to have to shoot someone. And what's the government's view in that regard?
A couple points
I mean,
on that.
that's not something you would, going back to what Judge Wilkinson was saying, teach at the academy, I would hope.
A couple points on that, Your Honor. When we're talking about the reasonableness of the force that's employed,
Objective.
it's
yes,
objective.
I understand
So
that.
it's-
I want to know why the government thinks this particular officer's testimony and conduct, in this case and others, is all right.
So the question is not, do we like this officer or do we like everything that he did in a particular case? The question is whether there was a Fourth Amendment violation, whether there's a sufficient causal nexus to that unlawful
Right.
conduct and the discovery of evidence, whether there would be inevitable discovery otherwise, and whether suppression is even available as a remedy. You have to check down through all of those things. And so
But
when
the
we're...
government doesn't agree that does not agree that whenever there's any type of crime that's committed, regardless of what type of crime it is, that the officers should pull their firearm, correct? I understand there's reasonable suspicion in this case,
So
but the
I think
government
that's-
does not countenance that viewpoint, does it?
I think if read in like the extreme, there are going to be problems that would flow from that in certain cases. However, there are also cases in the 1983 context where officers are drawing their firearms.
Answer my good colleague's question by saying, no, there's no way in the world we would countenance that broad a rule. But wait a minute, we're looking here at a very specific situation and a specific set of circumstances, and that's what the judgment involves. But I don't know why you would hesitate at all to respond to Judge Thacker's question and saying, under no circumstances does the government think that you can be just drawing your weapon as a matter of course. There has to be something a lot more than that before you draw your weapon. But Judge Thacker's right, isn't she, that this whole idea of just drawing your weapon as a routine matter, that can't be right, can it?
Your Honor, I agree. And I apologize if I was a little more hesitant than I should have been in responding to that. My answer to Judge Thacker was that if that were to be true and read in the extreme, that it would create Fourth Amendment violations in certain contexts. It depends on the facts of each individual case. And the case that we have before us is not one in which the drawing of the firearm was constitutionally excessive. And indeed, my friend has abandoned that.
You didn't shoot somebody in this case.
Your Honor, he did not shoot somebody in this case. And I hear Your Honor adverting to, I think, the letter that my friend filed.
Perhaps.
Okay, there's no evidence in the record about other conduct by
understand.
Officer Walker, so I don't think it's going to be a basis to conduct the analysis here. And I would encourage the court to ignore that. I think, honestly, dovetailing back to the remedies section, that's maybe more of an analysis that would be more appropriate in a 1983 case.
So can I ask you then, okay, I'm just going to say, I think there is significant force to your colleague's point that the district court's analysis seemed to really blend causation and inevitable discovery, which seem like they are conceptually separate questions. First, factual question. Is there any, so as I understand inevitable discovery doctrine, it's not necessary for the government to show just that the officer could have gotten the evidence the other way, which I think he clearly could have here, but you also have to show that you would have gotten the evidence the other way. Is there any evidence in this record? Like, for example, was this officer ever asked, what would you have done had you not drawn your gun? Right? I don't see anything in the record where the officer testifies, I would have done the thing that would have gotten me the, am I right about that?
There's no specific question along those lines, but there's also no legal requirement that there be a specific hypothetical, like counterfactual
No, but
hypothetical
no,
question.
hold on, but we've been really clear on the inevitable discovery doctrine. It is not enough to say you absolutely positively could, and I've seen a lot of these cases, and the government frequently tries to argue that because we obviously could have done it, inevitable discovery applies. And this court keeps saying over and over again, it is not enough that you could have done it, you have to show that you would have done it. And I don't see anything in this record that establishes he would have done it.
So I guess where I'm resisting the premise of Your Honor's question is that you don't need a specific question and answer.
Oh, I
along the
agree.
lines
You
that
need
you're
that.
suggesting.
But
So
you're not fighting my premise that those are separate requirements that both have to be met.
They are separate, yes, and Alston's very clear on that. But I would also point Your Honor to the Alston case, where the district court there very clearly omitted the finding that the officer would have taken the actions that would have led to the inevitable discovery of the evidence. This court nevertheless affirmed without a remand on the basis that the evidence that existed in the record, and there's no reason to think that that counterfactual that Your Honor is positing existed in that record, it was so obvious that the ministerial steps that an officer would take in that scenario would have uncovered the evidence. And the same is true here. Remember, the officer developed probable cause for a drug distribution offense before he even opened the door to this car. No reasonable officer is going to see that conduct happen right in front of his eyes and not, at the very least, conduct a Terry frisk.
And the minute we do that, we find the gun.
And the moment we do that, we find the gun. There's no dispute about that. It's on his hip. It's not, hidden in any meaningful way. It would have,
So
of
your
course.
argument here is that the facts and circumstances would satisfy the Wood test.
Yes. Yes, Your Honor. That's absolutely right. We do need an evidentiary foundation. I think this court's cases make it pretty clear that no particular form of it is required.
What Judge Heitens is saying is a correct articulation of the inevitable discovery rule. It's not, oh, there's a possibility that I would have discovered. I mean, I think that the question is a would question, not a could question.
Yeah, it's both. Yes. Both would and could. And here there's no dispute about could. I don't hear my friend disputing that. He's not really even disputing would. He's saying the government didn't provide a sufficient evidentiary basis for the would. But we just completely disagree with that.
Well, and there's no finding by the district court.
So, Your Honor, at JA 145, it says, regardless of how Officer Walker carried out this concededly permissible stop, he would have discovered the firearm, whether during the course of a Terry frisk or a standard search incident to arrest. And so he says,
Well, but that,
he would have discovered it.
This is the part, I understand you're putting the best spin you can on it, and maybe but when I read the district court's opinion, I do think there is force that the district court is mixing up causation and inevitable discovery. Because the court says, what the court says is the government makes three arguments against suppression, right? One, you can't ever suppress excessive force. Two, no causal connection. Three, there's no Fourth Amendment violation. The district court does not list inevitable discovery as one of the three grounds in which the government is seeking to oppose suppression, right? And it says, I'm picking option two. Option two, the court had identified as no causation, right? That's all true, right?
that's all true. I will just note that we separately argued it below, but we did put it in the same causation section in our opposition to the motion to suppress.
So you led the district court astray into thinking these two doctrines that are not the same are the same?
They're not the same, but they are related. If you look at Utah versus Strife, it's quite clear that the district court sees these as conceptually related. Attenuation, independent source, and inevitable discovery are all doctrines that are related to the causal relationship between two events in time. And so it's not really any surprise that in subsequent sentences next to each other, on JA 145, the court's going to make a no causation finding, and then in the very next sentence, adverting to the Terry stop and the search incident to arrest, he's going to make an inevitable discovery finding. He doesn't use the words explicitly inevitable discovery, but there's no real other way to read he would have conducted a Terry frisk and he would have conducted a search incident to arrest other than as the inevitable discovery analysis. So I think that's what we have. We also, of course, it's even more patently clear that the court did make a causation finding. We believe under Najar and Billette that that's basically a factual finding that's entitled to significant deference.
That seems strange, given Ornelas and all kinds of Fourth Amendment doctrine where the Supreme Court says over and over and over again, the bottom line Fourth Amendment questions are always reviewed de novo.
That's not correct, Your Honor, because in the inevitable discovery doctrine analysis, this is Billette.
Right. So whether they would, I agree with you that whether an officer would have done something seems like a factual finding.
Right, and the ultimate decision on inevitable discovery is fundamentally a factual question that's entitled to deference. That's Billette. In the jar, the court says that the attenuation doctrine, that type of analysis, is fundamentally a factual question that's readily susceptible to disposition by the district court. In other words, that it's entitled to deference. There's no logical reason to treat causation analysis, which is like the factual question of like, did event A cause event B? That's a classically factual question that like we would expect a jury to decide in a torts case. And there's no logical reason to treat that analysis differently from attenuation and from inevitable discovery, which this court has clearly held are factual and entitled to deference. But regardless, the court was not wrong under either standard to say that the drawing of the firearm and the pointing of the firearm bore no causal relationship to the officer's discovery of Mr. Coe's firearm. That was a thing that happened because Mr. Coe was caught selling drugs out of his car and was attempting to be apprehended and arrested by the officer. It had nothing to do with the fact that the officer drew his service weapon. I see I have 2 minutes remaining. I think I'd like to just turn back briefly to the remedy point unless the court has any questions on the reasonableness of the force. Oh, actually, I'm sorry. I did have, at the very beginning of my argument, I promised two corrections. One was to read that language from Foote versus Dunnigan, which shows that the officer was pointing his firearm and that was not impermissible. The second is my friend, at multiple points during his opening argument, adverted to the notion that this officer had his finger on the trigger for some meaningful length of time during the encounter. That factual finding is not in the record. He attempted to establish it. The officer at 113 to 114 repeatedly denied it, and the district court never found it. On the standard of review that we have, this court is viewing the evidence.
That didn't happen, given the district court's just, is that what you're saying? That because the district court didn't, because it was disputed and because the district court didn't find it happened, we have to assume it didn't happen?
Exactly. In order to find that it would happen, you would need to basically draw a factual inference in favor of the defendant, which is impermissible at this stage, given that the government prevailed below. Now I'm down to a minute. So I'll just close by saying that the reason why suppression should not be available as a remedy here has to do both with the mismatch between the interest protected by not wanting someone to be subject to excessive force and the interest protected by suppression of evidence in general. As the Supreme Court recognized in Hudson versus Michigan in the knock and announce context, the interests governing knock and announce are very different from the reasons why you would want to suppress evidence. The same is true here. And for similar reasons, officers faced with the prospect that evidence might be suppressed in the excessive force context are not going to be deterred because officers are not using excessive force with the idea that they will uncover evidence that they wouldn't otherwise be entitled to uncover. As long as the evidence, as is concededly the case here, was entitled to be found due to probable cause or due to reasonable suspicion, there's simply no logical connection between the excessive force and the suppression of the evidence. And for all these reasons, we'd ask that this court affirm. Thank you.
Right, thank you. Mr. Camden, you have rebuttal time.
Mr. Kempton, rather than interrupt what you were planning to say, I want to just ask you this up front. I was going to raise the thing that your colleague said at the end. Where is the factual finding that there was a finger on the trigger at any point? I was looking, and my assistants were also looking, and we cannot find any factual finding by the district court to that effect.
No, the district court assiduously avoided having to make that factual finding by resolving it on the legal question of just causation and whether it was there.
But now that the case comes to us after you lost at a suppression hearing, after an evidentiary hearing, don't we have to construe all facts in favor of the government? So if the district court didn't make a finding that it happened, don't we have to assume it didn't happen?
No, Your Honor, because
What's your authority for that proposition?
well, simply because there was never a finding one way or the other on
Sorry,
it.
what's
so-
your authority for that?
Oh,
I know
sorry.
there wasn't a finding, but I
Right.
think I can recite case after case after case after case that says, after an evidentiary hearing, we construe all facts in the light most favorable to the party that won below, that's them. And so in the absence of a finding that something happened, why don't we have to assume the true facts are that it didn't happen?
Well, the district court's findings are reviewed for clear error.
Sure.
The video.
Where in your brief do you say that was clearly erroneous for the district court not to find that the finger was on the trigger?
I don't believe it was specifically argued as a.
I don't think it's argued anywhere in your brief.
So what do you base that on, that the finger was on the trigger, when the officer denied it and the court didn't make a finding?
Oh, it's right there in high definition video from a camera that was about 6
So
inches
on
away
the video
from us.
itself?
Yes, Your Honor.
Which, so maybe argument heading one of the brief could have been the district court clearly erred in not finding the officer's finger was on the trigger, but it's not in your opening brief.
Well, Your Honor, I think the district court never reached the factual question of whether force was used because it avoided it by making this legal error in the first case. So if the court were to find that there was an error in finding no causation here, that actually pulling out the gun, sticking it in his ribs with his elbow on him actually led Mr. Coe to start to flee, and that there was causation because this was just an
Counsel,
unbroken...
one thing I'm concerned about here is the possibility of losing the forest for the trees. And I always like to ask myself, well, what would the takeaway from this case be if we were to reverse the district court in this situation and order a suppression remedy? I worry that the takeaway would be that even in situations where there was some legitimate fear that an officer's life was on the line, an officer has been frozen by the courts into a posture of inaction. And that, you know, once one clears away all the bramble bush, the ultimate takeaway might be in these sorts of circumstances, which officers encounter not infrequently. The officer has been told by the court that reasonable protective measures to save one's own life are not possible, and that's a real tough takeaway from the case. You can immerse yourself in the details of it, and some of them, frankly, are a bit fuzzy to me. But the overall point that would be drawn from this case gives rise to some apprehension on my part.
Actually, I'll make it very easy, Your Honor. I agree with the court that the standard should be that an officer is allowed to use deadly force or the threat of deadly force when they reasonably
What's the
believe-
discernible limiting principle here?
When an officer reasonably believes that his life is in danger, he is absolutely entitled to use deadly force or the threat of deadly force. But I think the problem we've got here is the record, and we need to hammer down the timeline. I usually don't go back and do the timeline here, but I think it's worth it. In this case, JA 95, he testifies he opened the door and attempted to grab Mr. Coe. JA 101, he says he did not see the firearm until the body-worn camera was knocked off. So everything you see on the body-worn camera is before he saw a firearm. It is exactly how he treats a citizen whom he sees in the community for whom she suspects of a drug crime when there's no evidence of a firearm. He doesn't see the firearm until they're struggling. And that struggle was because he was trying to get away because the officer had put a gun in his ribs, essentially. So the record here is that he had this encounter thinking he was just dealing drugs. He had white powder in his lap, and the response is pull out a gun, finger on the trigger, and put it up against Mr. Coe's side. So that's the record we have. In a case where the officer reasonably believes because somebody is armed or because there's furtive movements or somebody's reaching for their belt or somebody is driving a car at them that they believe reasonably that deadly force is necessary to protect their life, they absolutely have the power and the authority and the right, in fact, to defend themselves. But this isn't that case. This is a case where somebody has white powder in their lap, is pulled out of the car with an elbow and a gun in their lips. So
So does the resolution of the case depend upon the exact angle at which somebody's arm is? Is that a principle that one can discern or whatever? I mean, you've been during your argument, we've been going like this and been going like this with your arms in different directions. And I don't fault you for that. That's a legitimate point for you to make. But what kind of principle can we draw from the fact that arms are this way or that way or another way or what have you? I mean, this is a bit of a problem, but
If I-
at
if I
any
could-
rate, we've given you a little bit of extra time, and I'm gonna ask my, Judge Heitens, do you have any?
I'm good.
We have no further questions of you, but I would like to acknowledge the fact that you're court assigned, court appointed, and you've done an admirable job, and I thank you.
I appreciate the opportunity, Your Honor. Thank you.
All right, we'll proceed into our second case. Excuse me, we're going to come down and greet you before we allow you to escape. All right, thank you. Ms. Pratt, we'd be happy to hear from you in United States v. Smith.
Thank you, Your Honor. Are you able to hear me all right? Can you hear me?
Maybe you want to lower it just a little bit, and that's perfect.
Okay, thank you. Good morning, Your Honors. I'm Fran Pratt on behalf of Robert Smith. May it please the Court, this case presents two closely intertwined issues: whether Robert Smith entered a knowing, intelligent, and voluntary guilty plea, and whether the district court wrongly denied Mr. Smith's motion to withdraw that plea. The issues are intertwined because the validity of the plea in the first instance is a major factor in withdrawing the plea, and because Mr. Smith's original trial attorney, who was in disbarment proceedings, was ineffective in his representation both before and after the plea.
So, Ms. Pratt, can I skip? I have a remedial question that I don't want to forget to ask, and once we get into that, it's going to given that your client has completed his term of imprisonment, so we let him withdraw his guilty plea. I'm just trying to figure out what's going to happen. Let's assume that we agree with you on these issues. He's going to agree to a time served plea, right? Like, that seems overwhelmingly likely what's going to happen if we do that.
I think it's not clear. That, I think, would probably
Because
be
if
our
he doesn't
advice.
do that, they can re-prosecute him, and this super favorable plea agreement he got goes out the window, and, right? I don't envy the task of the federal public defender who have to explain to him, like, so good news, we won the appeal and you can withdraw the guilty plea. Bad news, that super, super, super favorable plea deal you got is out the window, and the government can now throw the book at you, and you might be way, way, way longer incarcerated as a result.
Your Honor, there have been cases where defendants have gone back for basically to start proceedings over.
I guess it says, I'm not going to ask you, but if I was a lawyer representing such a defendant, I would say you would be insane to withdraw your guilty plea under these circumstances. You've already served all of your prison time.
I would not disagree with that, Your Honor.
So then what is the evidence that he would that he would not have pled guilty otherwise?
Okay. If I could just, I will answer that question, but I notice the clock is not moving, so I don't want to, I think,
odd.
because of the issues about making sure you could hear me, so I want to,
It started and then it stopped.
yeah.
Thank you.
So
Thank you.
I don't want to overstay my time. The evidence is at the evidentiary hearing. Mr. Smith stated very clearly, and this is at JA page 224, quote, "I was resistant to pleading guilty from the very beginning because I paid him," his attorney, "to go to trial. I didn't pay him my hard-earned money to take a plea, and the only reason I took it is because he wasn't prepared to go to trial." That's, I think, a very clear statement that
What took him so long to come to that conclusion?
He ended up talking to other lawyers after the plea, because he grew more and more dissatisfied with what his first attorney did. It was at that point he discovered both that the statement of facts that he thought he signed was not in fact the one that was filed. It's also at that point that he learned that his previous attorney had just been recommended for disbarment in the District of Columbia.
Was there any material difference in the statement of facts that was filed and the one that appellant saw?
Your Honor, I have gone through, and I think the government says it's mostly stylistic. I think that there is one point where, near the beginning, where it was the statement of the second one was, I think, more clearly drafted and easier to follow.
But we have the Nicholson and Moore cases, with which you're familiar, and they dealt respectively with periods of 6 weeks and 2 months before the motion to withdraw was made. And in both cases, the court said, well, that 6-week period and that 2 months period, that's too long. And here you have a much longer period, from July 25th of 2023 to February the 9th of 24, when the motion to withdraw was made. And you say, well, that's mitigated by the fact that he was appointed new counsel in November. But at the same time, even if the period is from November to February, that's still longer than the periods in Nicholson and Moore that were ruled too long. And so even accounting for the appointment of new counsel, how do we overlook the period of time? Because what you're worried about is that if there's a problem with this, or you feel coerced or something, that would come to you normally within a relatively short period of time. And what we don't want is somebody just sitting in prison and having a case of buyer's remorse over time and saying, well, I think I could have gotten a better deal. So how do we deal with the length of time between the motion to withdraw and the plea itself?
Your Honor, the Moore factors include the amount of time as simply one factor, and it is a balancing test among all of the factors, so that
Well, it may be just one factor, but, there are a number of other factors to consider here, and one of those was prejudice to the government. And this plea was entered right on the day of trial, or the day before trial, which goes to the question of the prejudice to the government here. And the government would have assembled its witnesses, and maybe jury selection would have proceeded, but the witnesses were there, they were told to be there, and everything. And then at the very last minute, a plea is entered, which is fine, but then when you later want to withdraw and you look at the fact that this plea was entered immediately before trial and asking the government to reassemble the witnesses at a time when their recollection is a bit fuzzier than it was at the time, there would be prejudice to the government in this situation, would there not? Because you're right about the fact that the length of the delay is one of the factors, and it's not the only one. But then when you go through some of the others, the prejudice to the government, that would be here when the plea comes in at the 11th hour, would it not?
It can be viewed that way, Your Honor. However, it is not, 2 points, it's not at all unusual for pleas to happen at the last minute like this. Furthermore, the government itself admitted, and this is at JA pages 34 and 35, the government admitted that this is not and has never been a complex or voluminous trial. In fact, they said it would only take a day to try and only 2 witnesses needed to travel. So there is not, while there may be prejudice, it is very minor in the grand scheme of things.
Okay, so let me take you to more factor 2, which strikes me as a really big problem for you. Has your client ever, including now, contested more factor 2, whether he alleges that he is actually innocent of these crimes?
He has asserted to us that he has...
Sorry, I don't mean that he said things to his lawyers. Has he, in any statement ever to the district court or this court, claimed that he is actually innocent of these crimes?
No, he has not.
And haven't we said that more factor 2, I mean, you're trying to minimize the prejudice factor in fairness, because we've said the prejudice factor is not super important, but we've said that more factor 2 is super important, right?
It is, but the court has also said that the validity of the guilty plea itself
Of course.
is the most important. And so if I could turn to that for a minute or two, I think it's very clear this was not a knowing and voluntarily, intelligently entered plea.
Can we go, before we get to that?
Yes, sir.
I will just say I'm deeply skeptic. So, I mean, I think there's an argument that this Rule 11 stuff is doubly forfeited, because I would say that the first thing, well, assuming you had constitutionally ineffective counsel, and I know you don't agree he did, first I would say if you have an effective lawyer who thinks the district court is violating Rule 11, they have to object at the Rule 11 hearing, because if they don't, that's forfeited. You try to get around that by IAC, let's spot you, that gets you around that. But I have read the motion to withdraw the guilty plea. It doesn't say Rule 11 once. It doesn't say the district court screwed up once. It says my lawyer repeatedly screwed up. And I don't understand how that preserves an argument that the district court screwed up.
Because the purpose of Rule 11 and the colloquy required by it is twofold: to ensure that as a constitutional matter, defendants enter pleas that are knowing and voluntary, and second, that adherence to Rule 11 also includes...
Sure, I agree with all that, but all kinds of things operationalize other things. The entire federal rules of civil procedure operationalize the due process clause. That does not say that by raising like a procedural due process objection, you preserve every conceivable argument that the district court violated some provision of the federal rules of civil procedure, because this federal rules of civil procedure implement the due process clause. That, I mean, what is your best authority for the proposition that you can say, my lawyer committed ineffective assistance of counsel, ergo, I've preserved the argument that the district court screwed up the plea colloquy?
In our motion to withdraw the plea, there was a section very much that focused on the fact that the plea was not knowing and voluntary.
And where did, right, but again, the fact that the Rule 11 colloquy implements the due process clause doesn't mean that the argument that that someone violated the due process clause means, like, it's just saying that one thing implements the other is not saying that they're not different arguments. And I guess what I'm asking is, what is your best authority for, so I've expressed my tentative or more than tentative view. What is your best authority for the proposition that I'm wrong about that?
I'm not sure how to answer that, Your Honor. I don't have anything at my fingertips.
Okay.
But I do think that looking at the plea colloquy as a whole, that the number of things that were either omitted.
But that's an argument that the district court violated Rule 11, not that you preserved an argument that the district court violated Rule 11.
Well, which is why I raised that argument first in the briefing, because it is key not only as an argument in and unto itself, but it is also the primary factor in the motion to withdraw.
No, I mean, I understand what you just said about there were some omissions here in the plea colloquy, there's no question. And we often get, there's such a long checklist that we often get, the district court is often zinged on appeal by saying, and legitimately, so, well, you should have mentioned this, you should have mentioned that, you should have mentioned this. The district court mentioned a good deal. Also, there were omissions. And so you have Rule 11H, which says immaterial omissions and everything shall be disregarded. It's a harmless error rule in the federal rules there. And then doesn't Rule 11H hook into the reasonable probability standard? And this is what I think Judge Thacker alluded to earlier. What reasonable probability is there that he would not have pleaded guilty? Because if there's no reasonable probability there, then substantial rights have not been affected. And given the fact that he was given a pretty good deal with 23 of 24 charges being dismissed, and given the fact that the evidence against him was pretty strong. I mean, his wife advised him about these trial exhibits, and there was all sorts of inconsistencies. And there were other witnesses who were going to testify that the addresses that Mr. Smith listed in an effort to secure the firearm, he never lived there. He listed these addresses and he didn't live there. So given the fact that the plea agreement was a good deal, and the fact that the addresses that he listed on his firearms form, a number of them didn't exist, he never lived there. So why should we conclude that there was a reasonable probability that he would not have pled guilty? It was a perfectly rational decision that he made. It was straightforward. It was the product of a rational calculation. How could we conclude that there's a reasonable probability that he would not have pled guilty? I don't understand how we take that step.
2 points, Your Honor. First, he testified that the only reason he pled guilty was because his lawyer said he wasn't prepared to go to trial. And related to that, a defendant can go to trial for any number of reasons, and simply to make the government prove its case, whether or not he has a defense. Second, I take issue with the court's seeming position that this was a really good deal. He could have pled straight up and gotten exactly the same sentence, other than he would have had to pay far more in terms of special assessments. That's it.
He could have pled straight up, but what do you estimate his sentence would have been had he gone to trial? A lot longer, right?
Well, not necessarily. He did receive a downward variance, and yes, the guideline range would have been higher, but I think that there also would have been arguments that he still should receive a sentence as low as he did.
But apart from the length of the sentence, and I hear your point in that regard, isn't it still to the advantage of a particular defendant to have the charges dismissed? In other words, if 23 of 24 charges are dismissed, that makes for a cleaner situation. It takes some of the burden off of the petitioner's back, and it may, if the plea agreement dismisses those, that may have some effect on the calculation of the guidelines range, or if not, it may have some effect on the point within the guidelines range that the district court selected. It might have some effect later on in terms of the way the Bureau of Prisons looks at his record. In other words, wouldn't it still be significantly advantageous to have 23 of the 24 charges dismissed?
Again, Your Honor, well, first, I see my time is up, so if I could answer your
please.
question. The significant difference in going to trial versus pleading would be whether or not he received 2 or 3 points for acceptance of responsibility. In terms of relevant conduct, all of the guns in the other charges still came in as relevant conduct, and that's really what that drove the guideline range. He received, I think, a fairly large bump for that. So the fact, whether he pled to those charges, even in a straight-up plea, or pled only to the single plea, the single count, that didn't change.
What about the acceptance of responsibility and the 3-point reduction that one gets from pleading guilty? Wouldn't that factor?
Depending on the case, yes, it can be a major factor, but in other cases, it doesn't make that much difference. So I'll reserve the remainder of my time for rebuttal. Thank you.
Indeed. All right, Mr. Durham?
Good morning. May it please the court. Nicholas Durham on behalf of the government. Your Honors, I want to respond first to one of the questions that was asked of my colleague, and it was about what was the best evidence of the ineffectiveness. What's the best evidence that but for the ineffectiveness, this defendant would have gone to trial? And there was a statement about how he testified that he did this because his counsel was not prepared. But what we see is that the district court expressly disavowed that, expressly found the opposite. The district court stated in its findings that this case was prepared and that this particular counsel was competent. So if that's their best evidence, we still have the district court finding in some ways the opposite.
What did the district court base that on, that this counsel was competent? I mean, the counsel was in disbarment proceedings while this was going on and has been disbarred in at least 3 jurisdictions, maybe more to come.
My understanding he's only been disbarred in District of Columbia, but still.
No, Maryland and Virginia as well, since he was disbarred in D.C.
I think he was suspended, but
Okay,
I do take your
Do we
point.
do we really want to spend your argument time having a debate about just how bad of a lawyer this guy was?
I mean, this.
No, and to be clear, the government's not here to say that this counsel did not make any mistakes or was the best counsel that there could
When
have
you
been.
really can't
But
say what, I mean, appellant said that his lawyer told him he was not prepared to go to trial, and that's why he went to trial. I mean, the government wasn't there, that the government can't discount what the appellant said was accurate, that that's what his attorney told him, can it?
the government can't necessarily disprove that that statement was made, but it can, and it has, I believe, disproved the overall context of the case was in fact prepared to go forward.
That who was prepared to go forward? The government?
That-
Or
The defense counsel.
based on what?
Based on, I would say a few things, Your Honor. One, the record in terms of what was being filed leading up to trial, the exhibits, jury instructions and whatnot, but then also in.
Didn't the counsel make a motion to continue saying, that he needed time to read all this voluminous discovery that had been turned over, when that wasn't true at all? The government said that wasn't accurate. that there hadn't been new discovery provided? Because surely the government would not have provided discovery at that late date.
There was discovery provided at that late date, Your Honor.
Well, what did the government say in response to that motion to continue?
What the government was
I
saying
thought-
is that
Go ahead.
the type of discovery that was provided at that date isn't of the kind that would require any type of delay.
For a competent attorney?
That it wasn't the type of discovery that was really that material to the trial itself, and it's not the type that would necessitate any kind of delay.
It's just interesting to me that you would start with sort of trying to defend the competence of this lawyer rather than just go straight to the bottom line, which it did not substantially impact or prejudice appellant, what happened here, because of the plea deal that he got, and there's no evidence that he would have withdrawn it otherwise.
And I do take your point, Your Honor, and again, I'm not here to necessarily defend this attorney's conduct, but what I do think is important is that the district court, in this motion, heard plenty of evidence about what this particular attorney was doing to prepare for trial, to prepare this defendant for the plea agreement, and ultimately found as one of many of the factors, as one of various of the more factors, that this particular counsel was actually competent. But I also agree that even if we were to assume that he was incompetent, we don't have the prejudice prong established, which would be part of the burden of the defendants to prove. And if I may, I'm going to turn now to the Rule 11 colloquy. And of course, Your Honors, the government, of course, is going to acknowledge that it was a briefer colloquy than many. But
I know that we've said this. I guess, can I just ask you, why is it so freaking hard for a district court to just have a checklist and cite all the, I see Rule 11 colloquy after Rule 11 colloquy after Rule 11 colloquy, where district courts fail to tell defendants things they are under Rule 11 and maybe the due process. Like, it's not that freaking hard to have a checklist and follow the checklist.
I would not disagree with Your Honor.
There are district judges who are perfectly capable of doing it, who do it in every case, but we see Rule 11, and it's partly our fault because we've said it's totally okay to just not do the things that Rule 11 says you're supposed to do.
Well, we haven't said that in every case.
We
It's
sometimes,
totally
we
okay.
sometimes say that, right? As in we,
Recently
sorry.
said it is not okay.
Right.
Your Honor, I would agree. Would it be a best practice? Absolutely. But I think the importance here is looking to the experience of this district court.
No, I don't have any doubt that the district court judge is totally aware of all of these things. Of course, any district court judge, but particularly this district court judge, who's an extraordinarily experienced. But the point of it isn't for the district court judge to show to us, not that they ever need to show us anything, that the district court judge is aware of all of these things. The whole point of this is to make sure that the person who is about to confess guilt to a serious crime is aware of these things. So I don't see how the experience helps you. Right? I actually think there's an argument that experienced district court judges are somewhat more likely to do this problem, which is because you know something and because you've said something 1,000 times, you assume that everyone knows something and you don't need to say all those things.
So, Your Honor, I think what's important here is, of course, as you have noted, the Fourth Circuit has stated that it has refused to enforce or require a script. It has refused to demand certain questions be asked.
It's just a little weird to say, saying the things that the rules require you to say is, oh God, we're not going to require you to have a script. I mean, like, the rules say you have to tell the defendant these things.
You're right, Your Honor. And I think by and large, this district court judge complied with Rule 11, or at least there was no reversible error.
So it seems that there are two things you could do that might not be the best thing for you to do. One, you could try to mount a defense of the plea colloquy, which is a bit difficult to do. Judge Heitens points out that she's got a checklist and it shouldn't be that hard. And you would concede that this is not a model plea colloquy. And the other thing you can do is you can try to defend this lawyer. And I think we're suggesting to you is that you don't really want to mount a strong defense of the plea colloquy or of the attorney's conduct. At the end of the day, there is Rule 11H, and there is the reasonable probability standard. And the question is, did the individual carry his burden to say that there was no reasonable probability that he would have not have pled guilty? Isn't that a fair way to approach it? You're not interested in defending this plea colloquy, are you?
Well, Your Honor, of course, the government acknowledges that there are some errors in this plea colloquy, just not reversible error. But as Your Honor is suggesting, yes, going to the harm element in this analysis, what the government would say is that this defendant has proven no harm in that any one of these particular errors, if they were to be errors, that there's a reasonable...
The Supreme Court, it's under an abuse of discretion standard, and the Supreme Court has said, in the interest of finality and others, that the reasonable probability is a high bar to clear, and at the end of the day, he still has to prove there was a reasonable probability he would not have pled guilty. And your argument has to be that, we're not here to defend the conduct of counsel. We're not here to pull up this plea colloquy as any kind of model, because they just aren't. But there's still the problem of the delay. There's still the problem of the government's prejudice. There's still the problem of the fact that the witnesses were prepared to testify that the addresses he listed were simply not places that he had ever lived. The testimony would have, as forecast, would have blown him out of the water. He got a pretty good deal with 23 of the 24 charges dismissed. So that's the argument. The argument is not that the plea colloquy was fine, and the argument is not that this lawyer's conduct is defensible, but the case still, your argument has to be that the case still has not been made that there was a reasonable probability that he would not have pled guilty. Isn't that the argument?
Yes, Your Honor. Yes, Your Honor, and exactly that. Even had there been a few questions about competency, even had there been a greater explanation of the sentencing guidelines in this case, and even had there been a fulsome explanation of the appellate waiver, there is absolutely no evidence that that would have led this particular defendant to all of a sudden decide that he's not going to plead guilty. At the end of the day, while they were, especially the appellate waiver, we do concede that was an error, there's no evidence linking any error to a harm, meaning it ultimately had no difference on this particular defendant.
I mean, you're lucky here because you have an explicit harmless error rule that is directed by the federal rules toward this particular subject. This is not one of the general harmless error rules. It is specific, 11H, to this particular situation.
And just to add on to that, because I think it was raised with my colleague, the government is asserting that here, in this particular circumstance, that the plain error standard applies. Actually, in reviewing the Rule 11...
It's not plain error exactly. It's a question of just reasonable probability that he would not have pled guilty. And that does tie into the third prong of Alano. The rest, but it's not a classic plain error situation, I don't think, but it does suggest, to the extent that it relates to plain error, it does suggest that a motion to withdraw a plea should be made sooner rather than later. And there was, under our Nicholson and Moore cases, the delay here was was longer than you might wish.
And yes, Your Honor, just in terms of, firstly, just in terms of the standard of review, the government would point to Edgerton, which is an unpublished decision, to be sure, but in that case, it was similar in that the defendant was contesting at the district court level the competence of his counsel, but never challenged the Rule 11 colloquy. And this circuit decided that plain error would apply because there was no challenge before the district court as to the colloquy, even though at the district court level, there was a challenge to competence. Now, in terms of the delay, we have asserted that there was a delay, but I think another key point is several of the allegations, and this goes to the credibility and the weight, but several of the allegations of the defendant, there was an incredible delay with that as well. And what I'm getting at is, for instance, the allegation that his counsel told him just to say yes to everything.
One thing I'm interested in hearing, Ms. Pratt suggested that the fact that 23 of the 24 charges were dismissed in the plea agreement really didn't confer much of a substantial or a tangible benefit. What do you say in response to that?
Well, Your Honor, firstly, in terms of there was a benefit, to be sure. First, there's the third
What do
point.
you say, what is the benefit? Because we have this all the time, that one of the components of a plea agreement is the dismissal of certain charges. And then the question is, well, did that really factor into the ultimate sentence? And what is the tangible benefit that a defendant gets from the dismissal of charges?
And I'm going to come to this point, but firstly, the third point would not have been at play had there not been a plea agreement. The third point rests with the discretion of the government to move for that. I would say also, in terms of dismissing those counts, oftentimes there's a grouping question, whether or not those counts all are going to group, and if so, would that add to the time? And then add to the guidelines that the particular defendant is facing. And then lastly, it also relates to the statute, the statement of facts. Apologize for misstating that. As part of the process of developing this plea agreement, there is the statement of facts that the government puts forward and negotiates with the particular defendant. Had a defendant come forward and just said his own statement of facts, of course it would have to meet the elements, but it's not clear necessarily that the probation office or the court would ultimately give him even the 2 points for acceptance of responsibility, depending on how a defendant chose to provide his own
To go back to
explanation.
A point that Judge Heitens raised earlier, and it's always a good thing to ask, is there any plausible case that can be made that this individual was actually innocent of the false statements, charges that were leveled against him? Is there any, because what you don't want to happen is somebody pleading making a plea and then only later to find that there was no factual basis for the plea and that there was actual innocence. Is there any, and I think this is crucial in terms of the reasonable probability standard, is there any plausible case that can be made that this individual was actually innocent?
And Your Honor, that would be no. The appellant has admitted that, and that was, of course, a big consideration, both for the government in the first instance in deciding whether to challenge a motion to withdraw, but then that was a key consideration, as Your Honors have seen, in the district court's determination to ultimately deny that motion. So that at no point was an actual credible allegation of innocence was brought forward was one of the most determinative considerations for the district court, and when he decided to deny the motion to withdraw. Now, just a few more points. One of the things I was getting out very briefly about the delay is Your Honor didn't ask about, how important is the delay. And I think it's just key that some of the allegations this defendant made were made in March or in April, like on the eve of the evidentiary hearing. And that was, for instance, that counsel told him just to say yes to everything, and also that he was going to get a misdemeanor and probation. So I think the court also has to look at, and this district court did, I would say, consider the delay in the allegations themselves. Why were they coming up so late if he knew, this defendant knew all of these things from the first instance?
Because what he didn't know was just how incompetent his counsel was, and that his counsel was in the process of being disbarred, because his counsel kept that from him. And appellant wasn't he in prison at this time? So he had to unwind just how bad all of this was, and all of the misstatements and lies that his counsel had told him. I mean, did the government know that the lawyer was in disbarment proceedings when you were preparing to go to trial with him?
No, Your Honor. We did find out later when this came up.
Right, and so did appellant.
Yes,
It
Your
took
Honor.
him a while to unwind all of this.
But I would
So I take your point about the delay. I think delay is a factor we need to consider, but blaming it on sort of the appellant here not complaining about his lawyer soon enough, I don't agree with that. But you have a lot of other good points.
But all I would say, Your Honor, to that point is that these issues he would have known at the time of the plea, and they weren't raised. The idea that he was essentially told just to say yes to everything.
Well, I mean, I'm sure you've done a lot of plea hearings, as have I. Ordinarily, the client does just say yes to everything. And so I don't think that's an unusual thing. But anyway, I take your point.
Thank you, Your Honor. But if they're seeing that my time is essentially up, if there are no more questions, then, of course, the government would ask that this court affirm.
Judge Thacker, do you have further questions?
I'm good.
Okay.
Yes.
All right, thank you. Ms. Pratt, you have some rebuttal time.
Thank you, Your Honors. Let me start with the delay in terms of allegations and what Mr. Smith knew. You have to keep in mind he had practically no experience with the criminal justice system. He had a prior conviction that was later set aside 30 years earlier when he was only 18. So he doesn't know how things are supposed to work, and he's finding all this out after the fact, and he started raising it. Second, in terms of the benefit of pleadings, as I mentioned earlier, because of the way the guidelines work, dismissed counts still count. The government, I have seen many cases in which the government has moved for a third point for acceptance of responsibility, even without a plea agreement, when it's a straight-up plea. In terms of a defendant providing his own statement of facts, all he has to admit to is the conduct underlying the particular count of conviction. So I think all of that highlights the importance of the district court's failure to explain how the sentencing guidelines work. In terms of the harm, or that Mr. Smith had never indicated that he wanted to go to trial, again, at page 224 of the joint appendix, he was very clear he wanted to go to trial. In terms of the sufficiency of the colloquy, Judge Heitens, I think you hit the nail on the head. At best, what this judge did was just use a checklist. There was no explanation of anything. He just, to me,
Used a checklist and then left a bunch of the things off that should have been on the checklist.
that, and also, even with what he did explain, I won't even say explain. He did not do the kind of job that every other judge in the Eastern District of Virginia does to ensure that the plea was knowing and voluntary. And then, finally, in terms of
This business about he wanted to go to trial, that could be raised in any motion to withdraw, could it not? That, I mean, if we credited that, that would, it would be a standard element of any motion to withdraw, isn't it? Wouldn't it? That's always the choice.
It is a choice, but it has to be a knowing and intelligently reached choice. And here, I think this court just cannot have confidence that this was a knowing and voluntary
But if he
plea.
had wanted to go to trial, would that have been so hard to say? No, I mean, I want a trial.
Not when his lawyer is telling him, just say yes to everything. And in fact, when it came to the question of legal innocence, which the court did ask him, he said yes, he did. You know, I think because of the way the question was framed, and I apologize, I don't have it directly at my fingertips, but it was clear that was an answer to which that he should have said no right off. But he followed his lawyer's erroneous instructions and said yes to everything. And then finally, in terms of the best evidence of ineffectiveness, the government didn't put on the prior attorney. So the only evidence we have is what was coming through the defense witnesses, and I think that makes pretty clear that this lawyer was not doing what he was supposed to do. If the court has no further questions, we ask that the court vacate Mr. Smith's conviction and remand the case for further proceedings. Thank you.
We thank you. Judge Thacker, did you have any questions?
No.
I do not.
Ms. Pratt, I'd like you, if you would, please, to stay by the microphone. I recognize that this is your final argument.
That is
before
correct,
the
Your
court,
Honor.
and that you have spent 30 years with the Federal Defender's Services.
That is also correct.
And you've appeared before me and others on many occasions.
Yes,
Your advocacy has invariably been well-informed, professional, courteous, also vigorous, energetic, and hard-hitting. And you have made the criminal justice system work ever so much better because of your efforts. And every member of our court, we are only 3, but every member of our court would like to express to you the contributions that you've made to our process. And I hope that it will always be a source of the greatest satisfaction, the contributions that you've made to our criminal justice system. And with that, I want to turn over the microphone to my dear colleague and friend, Judge Thacker, because I believe she may have some remarks to make to you as well.
Well, of course, I concur in everything that Judge Wilkinson said, and I just want to add my thanks as well for your very able and zealous representation of your clients over these 30 years. It's so important and continues to be so more and more every day. Thank you.
Thank you, Your Honor.
The only thing I'll add is, I've only been on this court for the very tail end of your experience, of your work in this court, but I am so glad to have been here for a very small part of it. And with that, I echo everything my colleagues say.
Thank you, Judge Heitens.
Now with that, we will come down and shake hands or fist bump, and I want you to know we wish you all good things.
Thank you, Your Honor. Can I get a transcript of this meeting?
It's recorded. It's recorded.
Well, is it still recorded? Thank you. Thank you for not pulling the plug so quickly. I appreciate that ever so much. And it's been a ride. There have been times that some of my representation has been very difficult, and appearing in front of this court at times has been difficult. But I just feel so blessed to have been able to spend my professional life doing this kind of work. So thank you for recognizing that. It means a great deal. Thank you. Well, perhaps we'll see each other in the A-non-adversary setting at some point.
Well, I certainly hope that will be the case.
Thank you.
It would be my pleasure.
And we can talk more about cats and other cats.
Exactly. Thank you. Mhm.
I haven't had actually here when one or two other cases of that, but I have tracked this. Check my whole I think it is.
That's what my record suggested was.
Yes.
Oh, well, I'm glad I got to review with the last, so.
Thank you. Yes.
All right. Ms. Hopman, we happy to hear from you.
Good morning, and may it please the court. My name is Virginia Hopman, and together with my co-counsel Rob Marino, we're here representing Mr. Sheriar and Mr. Gondel, who are the appellants in this case. In addition to the final order issue that the panel requested we address, we bring two issues to this court warranting reversal of the bankruptcy court's decision to deny appellants back pay and back salary from AABCS, the judgment debtor. The first issue is the bankruptcy court applied the wrong legal standard to exclude
Wait, really the first issue, before you get, we wouldn't get to those issues if there's not a
final order.
So maybe.
So I can address that first, yes.
Would you?
Yes, this order was a final order. The district court, if you look at the language of the order, which is a JA 833, the district court specifically affirmed all decisions in the
Sorry,
court.
JA what?
I'm sorry, 833.
Are you sure it's not 831?
Well, it could be. I don't have the appendix in front of me. I wrote down 833. I apologize if I'm wrong. Anyway, she affirmed all of the decisions of the United States Bankruptcy Court as set forth in the appeals that were in front of her.
Sorry, that's the written order?
This is the written
No,
order.
I'm sorry. But the written order just says, for the reasons, do we agree that the written order has no reasoning whatsoever?
It has no reasoning
just-
whatsoever,
It just says, look back at what my oral ruling was.
but it clearly says.
Right, but
that
we've repeatedly said that is not enough. Just because the district court enters an order that purports to resolve all claims against all parties, that is not enough. Let me rephrase. That is certainly not enough under 28 U.S.C. 1291. We have
Yes.
said that
Yes.
multiple times.
Now, the Estate of Cunningham case, which was decided earlier this year that you asked us to address, involved just a different situation. It was a trial judge, it was a district court acting as a trial judge, and the appellate jurisdiction was 1291. This case, the bankruptcy court acted effectively as the trial court, and the district court was exercising appellate jurisdiction. So this court's jurisdiction is under 158D.
But doesn't that also say final decisions?
It does, but
Which is the same language as 1291?
It is, but the Leclerc decision, which was decided about the same time as the estate of Cunningham decision by this court, reiterates that the strict finality requirements of 1291B do not apply in the same fashion to 158 with
Sure, but
bankruptcy
that's-
cases.
Sorry, I'm sorry, I'll cut you off. Because it does not apply in the same fashion to what cases? In bankruptcy
In
cases?
bankruptcy,
But that
yes.
seems like that's saying that the strict finality rules that apply for our ability to review a district court under 1291 do not apply to a district court's ability to review a bankruptcy court under 158D. No one is disagreeing that Judge Brinkema had jurisdiction to consider this appeal. The question is
Right.
whether we have jurisdiction to consider Judge Brinkema's decision.
Right, but this court's jurisdiction is also based on 158D, which is the same.
Is the statute that gave Judge Brinkema jurisdiction, does that statute say final decisions?
Yes.
Final decisions?
Fine, yes, but finality is described differently. It is described as finally deciding the discrete issue that's in front, because bankruptcy cases involve complex decisions that don't all end at the same time. And in fact, this case was an adversary proceeding, which in and of itself didn't involve bankruptcy issues. It just arose in the context of bankruptcy. Even the Cunningham court, however, recognized that the district court need not specifically reiterate or mention each claim against each party in the order. And instead, it cited some earlier cases that looked at whether or not the language used by the district court encompassed all claims. And here it's clear that this language that I quoted earlier does encompass all claims. And at the beginning of the hearing, the district court stated that Judge Brinkema, she had considered all the issues, she was familiar with all the issues, she'd read all the briefs, she'd made her decision, and she only had a few questions to ask counsel. So it wasn't a traditional argument where each issue might be addressed.
Okay, so let me put it this way. Could you complete the following sentence? Judge Brinkema rejected the ratification claim because...
Yes.
I have no idea based on her oral ruling. I have no idea why Judge Brinkema rejected the ratification claim.
Yes, okay. I would say the reason she gave for...
Sorry, she gave a reason. Where did she give a reason? I have the transcript in front of me. Where does Judge Brinkema give a reason for rejecting the ratification claim?
Let's see. I believe, I could have the page number wrong, but I believe it's 830 and 831 of the appendix. And that is where she basically said that the bankruptcy court had reached a fair and equitable resolution of all of the claims, that none of the parties received everything they asked for.
That has
And
nothing to do with ratification.
it is one of the issues that
Ratification is by
that
putting
appellants
this...
raised.
I totally agree. It's one of the issues they raised, but the ratification claim isn't whether this is a fair and equitable and you received. It's the ratification, I understand, is because you put this on your tax return, you were saying you were okay with it. And
Well, that was part.
saying fair and equitable does not explain why you
Well-
put it on your tax return isn't a reason that that party wins.
I would agree. But I think it's equally a reason for affirming that decision as it is for affirming a decision to exclude lay opinion testimony on the value of your own testimony, that the Judge Brinkema essentially was saying that there were no clearly erroneous findings of fact made by the bankruptcy judge, and any error, such as the error in excluding the salary testimony, in her view, was not sufficiently material to warrant dismissal or
So
reversal
you view
of
this,
this
this
case.
is the paragraph on page 831, lines 11 through 14, where one way to interpret Judge Brinkema is that she's just summing up her conclusions that she's already given. But you would have us interpret that as saying, these are global reasons that cover all of the claims. That's the theory of finality.
I would say, and I would say at the beginning, she specifically stated that she was familiar with all of the issues in front of the court. And so there isn't any requirement that an appellate court explain each and every reason in order for its order to be final.
I gather you said earlier that none of the parties received everything that they had asked for. I suspect that indicates a certain desire on your part, or maybe I'm misinterpreting it, but to lay this case to rest rather than to send it through another round.
Well, I think there is
to
the
remand.
basis, there is the basis to do so here in the ratification issue. I think on the issue of the back salary, I do think that issue, if the the bankruptcy court's decision is reversed or vacated, would.
I realize you can take issue with this or with that. But as I understand it, in getting 24.5% of the proceeds of the vehicle sales, and that amounted to what, $55,000 for each. Your clients didn't walk away empty-handed
They did not.
by a long shot. I mean,
They did
$55,000 isn't just trivial. And as to, I know your chief complaint is, well, but we didn't get a proper evaluation of our salary and what we were due. But you did get a lot, and let's assuming that the district court or bankruptcy court really was wrong in saying you need an expert witness to establish that. I'm not sure that you do, but the point is made that the valuation would still be, the valuation of your work would still be in the speculative category, that there was no way to pin it down. And, is that really worth a remand and keeping the meter running when you've received $55,000 and when the bankruptcy and court's view or the district court's view is that the value is still going to be speculative? Is there a reasonable chance that anything is going to be different?
I think there is, because I think in this case, Your Honor, I don't believe that the bankruptcy court said that any testimony on value would be speculative.
Yeah, I'm not
It
so
was-
sure why,
it was-
I'm not so sure why you all didn't settle this thing to begin with. It
Well,
seems-
that was what took up most of the argument in front of Judge
But, I mean,
Brinkman.
that's your choice, but it seemed to me to be a case that cried out for settlement, but that's okay. You decided to come to court with it, and that's your perfect right. But at this late date, what is to be gained by sending it back to a court that already believes, the courts that already believe that this figure you want or this money you want for salaries is of a speculative nature? I mean,
Again, I don't believe that the bankruptcy court made that finding or discussed speculative nature. His decision seemed to be
well, but what about the
that
district
unless-
court?
Well, the district court went in a different direction and talked about how she would have, had she been the trial judge, required corroboration like she does in contested Fair Labor Standard Act cases. But in this case, there was no objection, there was no contest regarding the number of hours. And, it may seem more abstract now, but looking back on it, these men worked, Mr. Sheriar testified, that he worked up to 90 hours a week. 90 hours a week, and the 55,000 does not anywhere near represent 3 years worth of back pay that wasn't paid because the company at the time didn't have the money to pay him. So he continued working, and so did Mr. Gondel, on faith that it would be paid once COVID cleared and the company
I
began
know,
to make money.
I certainly understand from your perspective what you're saying. Bankruptcy law has a certain equitable component, and $55,000 isn't chicken feed. And I know you want more. I know you deserve more.
I see my time is up, but I
You've
would
got some rebuttal, and
I
you
would
can
like to
save it for rebuttal.
save it for rebuttal.
I need to be convinced that it's worthwhile to keep this going and going and going and going, and what we're likely to achieve by letting the meter run and proceedings.
Well, we
drag
could
on.
talk about
And that's for-
ratification. That
that's
would be
for
different.
rebuttal. You just tell me why I'm wrong.
All right, we'll do.
And wait a minute before you leave, Judge Thacker,
No, I do not.
I do not.
okay.
Thank you.
Mr. Forrest?
Thank you. May it please the court, John Forrest for All-American Black Car Service. To answer the jurisdictional question first, I agree substantially with what my colleague has said. One distinction I would draw is her comment that the adversary proceeding.
So this is the bankruptcy exceptionalism theory. That bankruptcy is just different. That bankruptcy is just different than regular appeals.
No. Her comment was that the adversary proceeding didn't involve bankruptcy issues.
Okay,
I just wanted to separate that out. I'll address it later.
sure.
Then to get back to the comment, in Cunningham, if I've read it correctly, there were the crane operating defendants who never filed a motion to dismiss. But their claims were wrapped up in the district court dismissal. I distinguish that from the case at hand because, as we've seen from looking at Judge Brinkman's comments, she said that she'd reviewed everything. And I guess this is Judge Heitens, it gets back to your comment. She says she's reviewed everything. She made an assessment of it. She made a lot of the same comments that you made, Judge Wilkinson, and just said, she said what she said, but I think the fact that she said that she'd reviewed everything, the issues were raised in the pleadings before the district court, satisfies the finality requirement.
Well, ideally, we'd like a little something more particularized and more specific than that general statement. The question that I have to ask is in a situation where neither party has objected to jurisdiction, I realize that doesn't relieve the court of the necessity of finding a final judgment. But where neither party has objected to jurisdiction and where the jurisdictional issue is close, and in my judgment, it is close and well worth our time discussing. But even in something as august as jurisdiction, it's possible that in close questions where neither party has objected, that you can let a practical consideration work in. And I'm wondering what would be gained by a remand of this issue, and particularly, I want to know what your response is to your opponent's response on the lost salary point. She is saying that the contributions, that the value of the minority shareholders' work and efforts was never fairly appraised, and that the idea of requiring an expert was not correct. And then, as I understand it, and I'm not sure I perfectly understand it, but I understand that the valuation issue is tied up with bonuses and other kinds of compensation maybe, but that it would be very hard to pin down exactly what the valuation issue was. But what I'd like to hear is simply your response to the fact that no, we can decide valuation and we haven't been fairly rewarded for the work that we put in. What's your thought about that?
Well, I would first separate the treatment of the two gentlemen, Mr. Gondal and Mr. Sheriar. Mr. Sheriar asserted these claims. And when I say it was rebuffed, the bankruptcy court made the rulings it did, that he needed expert testimony. But Mr. Gondal presented no claim. And in fact, I think it's in finding of fact number 33, and I'm sorry I don't right now have a joint appendix reference to it, but finding of fact 33, the bankruptcy judge found that Mr. Gondal had no claim.
All right, but let's suppose we don't separate them, because if you separate them, that would require further proceedings and some sort of different disposition for each of the minority owners. But what is your response to her point about the fact that this salary, that they put in work for which they were never compensated? Just give me what your response is. Is your response no, they were compensated? Or is your response that it's all so speculative it is impossible to pin down? Which of those responses is it? And explain.
It's actually both. They were.
Well, why is it both? Just explain it to me. It's neither a friendly question or a hostile question.
Understand. I think it was Exhibit S or T in the bankruptcy court, which reflected substantial payouts over time. During the course of the bankruptcy case, Mr. Chima was examined with respect to, again, I'm sorry, I don't have the lettered exhibit, S and T. It was a substantial, I don't want to call it payroll records, some substantial banking records. And they asked Mr. Chima, you got X dollars on X date, what was that for? If this court were to look at that exhibit, you would see that there were substantial payments that were made to Mr. Gondal and Sheriar. They weren't treated as wages.
How were they made? In what form were they made?
Dividends.
In what?
They were called by the parties at the time dividends. So the equitable argument, not the equitable argument, the argument would be, if we had to respond to that, was that you received payment, you received substantial payments. They just were not, at that time, denoted as dividends. But
Okay, you're saying in a closely held corporation where there's several where the minority owners are actually employees in a sense that compensation can come in the form of a dividend as well as a wage?
It can, but my broader answer to Your Honor's question is that these gentlemen were not unpaid. They received substantial amounts of money. The money may not have been called salary or may not have been called wage payments at the time, but they received substantial money.
Okay, they received substantial money, but that answers that responds to the first question about whether they were compensated. The second question I had, and you said this was also part of it, is that the actual valuation would be very difficult to pin down.
Well, it would be difficult to pin down, but I believe that the bankruptcy judge was correct in determining that expert testimony was required to pin down not only the value, but also I believe the bankruptcy judge rejected the contention of just someone, and I don't mean to say be casual here, but someone just saying, I work 90 hours a week. I don't think that evidence was sufficient, that the bankruptcy judge viewed that evidence as sufficient as to the number of hours before we get to the question, before the bankruptcy judge got to the question of what those hours might be worth.
Are you basically content with the way things are? I know you leveled across appeal, but you didn't get everything you wanted. You wanted lost profits, et cetera, et cetera. You didn't get those. You didn't get everything. But are you content with what you did get? Are you happy basically with what the bankruptcy district courts did?
No, we are not. We are equally displeased, as opposing counsel is. Well, perhaps, maybe there might be a question of degree, but unfortunately
everybody
no.
got a little something. I mean, you won on some points, okay, and you lost on some points. And naturally, each of you is displeased with the points that you lost on. But overall, bankruptcy courts have an equitable component. This was a decision that split the baby. You know, it gave it ruled for each side some of the time. Everybody got a little something, nobody got everything. You know, is it really worth, you know, running the meter and keeping all this stuff going and churning and going? And is that really a wise course for us? Or wouldn't the wiser course, even though you'd be disgruntled with the little piece of it you didn't win, you'd say, well, okay, you know, sometimes a compromise you win by not losing everything. And would you be basically, okay, you know, let's call it a day?
Well, I hope I'm not going to go too far outside the record in answering the question, because I think the question does fairly take me outside. There haven't been any settlement discussions. So
Even after Judge Brinkema said as clearly as she possibly could, you really, really, really need to settle this case?
yes,
So you thought the response to that is let's continue to not do the thing that the district court said in the strongest possible terms that you really, really, really should do. Like, she started out the hearing, like literally the most thing that comes clear from Judge Brinkema at the hearing is, I don't understand why this case hasn't settled. And even after that, no settlement discussions.
to be as direct as I possibly can, Your Honor, we asked for an offer, we didn't receive anything.
Got it.
Multiple times. So we're left with what we have.
The perfect is the enemy of the good. Sometimes it's good to leave well enough alone. I mean, I realize what I'm suggesting isn't ultimately satisfying to anybody, but, you know, sometimes life doesn't work out that way.
I understand, Your Honor, I do.
All right, let's.
Unless there are questions, I'll save my time for.
Judge Hyten, did you get
I'm
it?
good, thank you.
Okay. All right, let's hear, Ms. Hopman, you got some
Answers.
rebuttal time.
Yes, first I'd like to address the settlement issue. We requested mediation of this, by this court when we initially filed our appeal, and our request was denied. So, in the past, any settlement discussions.
You didn't have the court's mediators, but you did have two mediators in the bankruptcy and district judges.
Right, we also, without a mediator, have had these parties have a history that is not conducive to fruitful settlement discussions. But putting that to one side, I do want to take issue with one thing my fellow counsel here said, and that was that they had been substantially compensated. Before 2020, they did receive as distributions, cash distributions, which effectively was a payment of their salary over and above the small amount that they were paid under W-2, what they called W-2 wages. And Mr. Sheriar testified to a great extent.
Compensated in some form.
Before 2020. We have at issue here is 3 years, 2020 to 2022. Those distributions were not made. So they were not compensated for the
Did you
90 hours a
receive
week.
dividends?
No, not during 2020 to 2022, which is what created the set-off defense that was raised in this particular case. And Your Honors, I do not think there were no complicated bonus systems. This was a pretty simple, straightforward case where there was testimony of exactly how many hours Mr. Sheriar had worked, and what he was not allowed to testify was what was the hourly value or the hourly worth of his work. And in effect, the district court applied a per se expert is required rule. And that is essentially the polar opposite of what this court did earlier this
Well, when
year.
you're all in a managerial role, and it seems like that in a way the company was managed more or less by 3 different folks.
It was 2, and they did everything but drive the cars. They did all the office work. Mr. Sheriar worked in the morning
All right,
shift
but-
and the afternoon shift, and Mr. Gondel took care of the cars, made all the repairs, made sure the fleet was still in
But-
effect.
When you received the $55,000 and the 24.5% of the vehicle sales proceeds, in a way, in a closely held corporation where there was a division or there was a shared managerial role, at least somewhat, is it possible that those percentages of the vehicle sales proceeds, which were explicitly designed to compensate you for your minority ownership position, sort of implicitly included compensation for
No.
salary as well? Why, I mean,
No,
why not? It
Because
seems
that
to
was
me,
a straightforward.
given this closely held situation,
Mhm.
and given, I mean, normally, maybe not, but given the particular structure of this company, it could be that the percentage of the vehicle sales that you received, the $50,000 that you got, or some of that was intended for compensation.
No, sir, that was a straightforward application of section 13.1745 of the Virginia Code, which is once the bankruptcy judge denied the back pay claim, there was $280 some odd thousand left over, and under that Virginia statute, because the parties had agreed to dissolve and had conceded dissolution, 745 requires that 50% or 51% goes to the 51% owner, and 49% was split equally between the appellants because they each own 24.5%. So that had nothing to do with salary. That was a pure application of that statute. And the salary claim is not only a straightforward application of what the value is worth, it is very similar to the Mountain Valley Pipeline case that this court decided earlier this year, where the court essentially said a lay witness can always testify as to the value of property that they own. And in this case, they were not testifying to anything they lacked firsthand knowledge or personal experience with. The only testimony they were going to give was what each hour they worked for the company and were not paid was worth. And they should have been able to do that. under the statute. But in addition, there is the ratification issue, which we do not believe would require a remand. And in that case, the bankruptcy judge conflated ratification with consent. And if you look at his language, he looked to whether or not the parties had consented to this, had benefited from the sale of the vehicles, which they'd already consented to. But then he looked to whether or not they actually consented to retain proceeds for salary, when instead he should have looked to whether or not they had, knowing all of the relevant facts, accepted the benefits of treating the salary, the proceeds as repayment of salary. And here there were two benefits. One, it was a discharge or a partial discharge of what the company owed in back compensation. It's the same benefit they received by paying third-party debtors. And the second is the tax benefit, because instead of treating it as a capital loss, which is what it would have been had they treated it as the theft or loss of the sale of those capital assets of the company, they treated it as a distribution in salary, which was the same way as my fellow counsel observed. It was the same way they had paid salary out before 2020. And there's testimony in the record about that. It seems pretty clear under the ratification cases that this court could make that decision. I see my time is up, if there's no.
Any questions? All right, thank you very much. And then, Mr. Forrest, do you have some further time?
Yes. Your Honor, to address the application of the statute, I think it was 13.1754. We don't think that the bankruptcy judge was applying that statute, but even if he was, it was incorrect to do so for the following reasons. Number one, the All-American Black Car Service had a plan approved, confirmed, excuse me. Article 10 of that plan provided that the confirmation order was a satisfaction of any claims regarding the status or the standing of the corporation. Exhibit 12 that was introduced in evidence at the trial was the complaint that Mr. Gondal and Sherryar filed in the Fairfax County Circuit Court asking for, in essence, among other things, a dissolution of the corporation. So upon confirmation of that plan, those claims for dissolution were forever barred. Because those claims were barred, it would not have been appropriate for the bankruptcy judge to apply the dissolution statute based upon principles of res judicata and collateral estoppel. The second argument that we have is that when All-American Black Car Service filed the bankruptcy petition under Section 301 of the Bankruptcy Code, that created an estate. The estate is a legal person separate and apart from the corporation. The estate was not a party to that, I just want to call it the dissolution agreement, the informal agreement that was reached by the shareholders. So the estate was not bound by that agreement. Because the estate was not bound by that agreement and because of confirmation of the plan, under principles of, under principles of res judicata and collateral estoppel, it was not appropriate for the bankruptcy judge to, number one, to allow Mrs. Sherryar and Gondal to keep that money. The essential question that we've raised in our, when I say question, we raised in our in the conclusion of, I think, our opening brief, we made the observation that as much as we appreciate, we didn't say this in the brief, but I do appreciate Your Honor's comment that what justice looks like in a bankruptcy court, and it's an effort to do something for everyone. But the essential question that we have is, how is it that these two shareholders are allowed to keep roughly half the money that they, I'm going to say, took, and retain their interest in the corporation? Those two facts should not and cannot coexist together. They are mutually exclusive. And the reason, part of the reason we're here on the appeal is, as much as we would have, I don't want to say liked it, I don't think the bankruptcy judge could say, you guys don't have the stock. You can't adjust that particular right, because that's a personal right they have. But the only solution available is for the bankruptcy court to find that the money that was taken, which was property of the bankruptcy estate under Section 541, belonged to the corporation.
All right, we thank you. Judge, you have any further questions? You have any further questions? We're fine. We will adjourn court and come down and greet counsel. I want to thank our courtroom deputy for all her wonderful service. Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.